All righty, we're going to go ahead and get started. Once again, I want to welcome everybody onto our April webinar. Tonight, our board member, Alyse Ferguson, will be talking about what to expect and understanding the mental health process, advocating, and what you can expect if your loved one and with a mental health condition enters the criminal justice system. My name is Jennifer, and I'm the program director here at NAMI North Texas. For this evening, I will be serving as the moderator. If you have any questions throughout Alyse's presentation, feel free to drop them in the chat. We will be discussing and answering questions at the conclusion of her program. Just really quick, do not forget that our virtual walk is going to be on May 22nd. That's NAMI Walks Your Way 2021. So don't forget to register for a team, create your own team, and continue to fundraise for us so we can continue to provide programs such as, the one this evening at no cost to community members. So please do not forget, May 22nd, NAMI Walks Your Way. All righty, that's all I have for you. I'm going to go ahead and turn it over to our board member. Alyse Ferguson is the Attorney Director at Collin County Mental Health Managed Counsel Program. And she's going to be presenting a little bit more about what to expect if your loved one with a mental health condition happens to enter the criminal justice system. So Alyse, I'll go ahead and turn it over to you.
Good evening, and thank you for having me. As Jennifer said, I'm the Attorney Director at the Collin County Mental Health Program. The county started this program in 2012 when the judges recognized that individuals with mental illness were spending about 400% longer in custody than those who were undiagnosed with any mental illness. And so they wanted to address these concerns as well as concerns with very long wait lists to the state hospital. So our office was created. And I think in terms of explaining to you what my office is, it's very much like a public defender's office. It's just arranged a little differently, but we provide public defense for persons who are indigent in our criminal justice system. So they get a court-appointed attorney through my office, and we monitor their cases and work on their cases throughout their time. Specifically, we want to work on a holistic approach and helping them get the services they need in an effort to keep them from re-entering the criminal justice system. Jennifer, if you go ahead and switch to the next slide. So first, we're going to talk about the mental health crisis before someone is ever in the criminal justice system. Go ahead. So there are two ways in which your loved one could get to a hospital for evaluation outside of a voluntary decision to go. One of those is known as an APOW. You've probably heard that term, or an emergency detention without a warrant. And the second one is an emergency detention with a warrant. So I'm going to talk about each one of those next. So first you have an APOW, and that's apprehension by a police officer without a warrant. And so this situation would be when you've called the police department because you have a loved one in need, in crisis, and you want assistance in getting them to a psychiatric facility. And I'm sure some of you have had an officer come out and tell you, I'm sorry, but they don't meet the criteria. We're not able to assist you. And the reason why is the officer has very specific criteria to meet. The officer first must believe that the person's mentally ill, and they must believe that the person is a substantial risk of harm to theirself or others. And they have to believe that if they're not immediately restrained, that harm may occur and there's not time for a warrant. So if the situation is, for example, a parent calls the officer out and says, hey, my loved one's been off medication for a week now, and I know they're fixing to crash, and when they do, here's what happens. And the parent is trying to be preemptive and get it addressed before the crisis, but that under the law, the officer does not have the ability to address it at that point. The person has to be having a need for immediate restraint and has to be a substantial risk of harm right then when the officer's out there. So that's their criteria. Next. The second way is with a warrant. So if the officer tells the family, we can't meet the criteria, they may also refer you to just go through the process of getting a warrant. And when you go through that process, and it's also called an emergency detention order, any judge can grant that. Usually it's Judge Copeland at our county mental health probate court, but it can be any judge or magistrate, a JP or municipal judge that's granting it. Go ahead to the next one. And the emergency detention warrant that a family member goes to get is really the same criteria as the officer. The person who's applying has to be over 18, and they have to believe the person has mental illness. They have to believe there's a substantial risk of harm to themselves or others, and they have to provide a specific description of the risk of harm. So one of the things I can tell you that will help you out as a family member is to keep really good notes. It's really great to keep them on the computer where you can just hit print when you need to. Very often when a family member is taken into custody on an EDO, the family member's angry and they don't want the hospital talking to whoever called the police or whoever got the warrant. And so it's very hard to share information. So anything that you provide with the warrant goes to the hospital and gives them more information to work with. So you should keep records about when the last doctor's appointment was, what medications they're on, are they taking their medications, who's the prescribing doctor, who's their pharmacy, what are the names of the medications. And all of this information will be extremely helpful to the hospital. I would also include prior hospitalizations and where they've gotten treatment, any diagnosis you're aware of. Because once that person's admitted, you're not going to be able to get information. You're only going to be able to call and check on your loved one if you have the code that's provided to you by that loved one. So it's very, very important that when they go to the hospital, they go with full information. Next. A little bit on age issues. You don't generally see anyone under 18 committed. There is a process for it involving CPS, but as a general rule, anybody over 16 can voluntarily admit themselves, and anybody under 18 can be voluntarily admitted by a parent. So there is no need for the court to be involved or to take any action. The police can take a person under 18 in on an APAL or a warrant for evaluation, but the parent can also make those choices without the involvement of the court or the police. If the parent is not making choices that the hospital or the police feel are necessary for the protection of that 18-year-old and under, then CPS may be called and may become involved and take action in those cases. Go ahead to the next one. We also had a new statute come out, I think it's been about 2 years ago, to address persons who are IDD in a facility. And I think this became very important because many of these group homes were calling the police out to address their behavior problems in the group home where two individuals had gotten into a fight with each other. And we were seeing these individuals show up in the criminal justice system. This was particularly concerning because many of them have a low functioning level. So you have somebody who's maybe functioning as a 10-year-old who's in a county jail with other adult inmates, and they are at risk for abuse and victimization. So it was important that there's some action to help prevent them from entering the system. So this law specified that if the person has IDD and they're in a facility operated by HCS waiver program, this is where it got a little sticky, because my first question was, okay, how does the officer know it's an HCS waiver program? And the answer I got was they're just going to have to ask when they get there. In the future, I'd really like to see this expanded to any group home instead of being very specific to HCS waiver, because it is important that all individuals with IDD are protected from this. And so that is one area of advocacy that we could work towards. So the law specifies that in lieu of arrest, the officer can go ahead and release the individual at the scene if he finds that confinement is not necessary to protect the individual and he's made reasonable effort to consult with staff on that decision. Another problem with the IDD individuals often is that they can't be prosecuted because of being incompetent to proceed. So this is a much better solution to address what's going on. It also prevents the individual from losing their spot, their housing, their income or other benefits like Medicaid or Social Security disability. Next. So another statute, this one's a little bit older. We're just still not seeing it used very widely because it's a little vague in some areas. So under the Sandra Bland Act, in the criminal code, police were required to divert people who have a mental health crisis or substance abuse issue. And the code gave police very specific instructions that if treatment was available and appropriate in their jurisdiction, and it was reasonable to divert the person, and it was a nonviolent misdemeanor, and they believed that the mental health crisis or substance abuse was suspected to be the reason that the crime was committed, then they shall make a good faith effort to divert that person to an available and appropriate treatment center. So what is a good faith effort has come into question. What is a treatment center? What's an appropriate treatment center? And I run into many officers and departments that don't even know this law exists. This is something that for example, the Houston Police Department is using. They're diverting criminal trespass cases to a center versus booking them into custody at a jail. And they're having great success with that. When someone's booked into jail, it makes it harder for us to get them services. And in fact, they lose a lot of services. And I'll talk a little bit more about that in a minute. But it's really important that we get police agencies on board with diversion and thinking about what other facilities or places are appropriate to divert. So in a mental health crisis, an appropriate diversion might be that they take the person in on an APOW or an emergency detention warrant, or it might be that they're calling MCOT, or that they're taking them to the crisis residential unit, or maybe a detox facility if substance abuse is involved. So it's really about using other alternatives when appropriate. Go ahead into the next one. A little bit on the commitment process as a whole and how it works. So whether you've called the police and asked them to help take someone to the hospital for you, or whether you go get an emergency detention order, that's the first step. Once your loved one is in the hospital on either one of those detentions, the hospital has to evaluate them within 48 hours. And they can only hold them for 48 hours. Now, if it's a weekend, it's going to extend till Monday or a holiday. It's going to give them a little bit more leeway to let the courts open up. But they have to be evaluated, and the hospital then has to determine if the individual should be continued to remain in custody of the hospital, if they need continued care. So if the hospital determines that continued care is needed, they file an order of protective custody motion with the court. The court, if they find that the person should stay in protective custody, they sign an order and the person is put into a psychiatric unit until the court can have hearing. They're to remain in custody. Now, most people don't remain in custody long enough to have the temporary hearing, but if they're very ill, the temporary hearing will occur within 14 days. At the temporary hearing, or at the placement hearing, the judge will decide if a temporary order or an extended order is appropriate. So the judge has a choice of saying, no, they don't need continued care, or I'm ordering they stay for 45 days, or I'm ordering they stay up to a year. Now, even if the judge says you're staying 45 days or you're staying a year, that doesn't mean they have to stay that long. It just means it can't be longer than that. So a person could stay 5 days, or a person could stay 10 days. The length of the stay isn't determined, just the maximum length of stay. If the judge ordered somebody to a temporary stay of 45 days, and that 45 days was coming to an end, and the doctors felt they should still remain in services, then the court would hear a request for extended services for them to stay longer. And the same goes for extended services. Anytime that time is coming to a deadline and the doctor feels that they need more time, the doctors will apply for another order to extend it. Now, when your loved one is in the hospital initially on that emergency detention, the hospital is supposed to come tell them what their rights are and what's happening. What I find is that the individuals either are in such crisis at the time they go in that all of that is just too much to take in and no one repeats it, or it doesn't happen. And so I constantly run into people who are very frustrated. They're in the hospital and nobody's telling them anything, and they're not understanding why they're still there. They're not understanding why they came in voluntarily, and now they're being told they're held on a court order. Somebody just walks into the room and says, your lawyer's on the phone here. They don't know they have a lawyer or why. And there is a true lack of explanation to individuals and their families about what the process is and what's happening. I hope that in the months to come, we can develop a little bit of a cheat sheet for you to have on the website where it talks about the process and bullet points, what's going to happen in order, so that you can share that with someone who's in the hospital for an understanding. When they have the temporary extended hearing, the judge will appoint them an attorney to represent their interest. And that attorney should be contacting them and meeting with them to determine what their interests are and working with them. It's a lot to take in when they're in the hospital. And so it's really important that there's advocacy at that point and educating them. I'm trying lately to reach out to hospitals and tell them what I've had feedback on and what I've experienced in people feeling a little lost as to what's happening next in their life. That's very frustrating when someone's having a mental health crisis and then they feel a further loss because they're in a hospital. They don't know what's happening next and they don't know what the process is. And that just adds a great deal of stress to an already stressful situation. Next. I want to talk a second about medication. I have families come in all the time, and I think one of the most frustrating things about my job is that I never get to give really good news to families. I always kind of have to give bad news, because the family will come in and say, you know, I called the police to take my loved one to the hospital and the hospital released them within an hour. They're not better. They need to keep them. I wished that that was something that could happen, but the law, as I explained to you a little bit earlier, is that the person has to be a risk of harm. And once that risk is over, whether it's because they've received medication or some other type of treatment, the hospital has to discharge them. The hospital can no longer keep them against their will. And some of the same issues apply with medication. They cannot involuntarily give somebody medication. If that person refuses, the only way that they can give the medication is if it's related to an emergency, or they've applied to the court and asked the court to grant permission for them to give the medication. So just because someone's in the hospital does not automatically mean that they're going to start getting medication and get it against their will. Many, many people go to the hospital and refuse the medication, and they don't meet the criteria for a forced type of medication. So that's another frustration for families, is that the person doesn't necessarily get medication. Next. I wanted to put this chart in just to give you an idea of kind of what's happened. It's very frustrating to me that many years ago, you know, there was a great movement to stop warehousing persons with mental illness in our state hospitals. And so we saw hospital closures. Unfortunately, yes, or fortunately, yes, we quit warehousing people in the state hospitals. And now we warehouse them in the county jails. The line on the bottom, the blue one, is forensics. And forensic beds are anything that comes in through the criminal justice system. The line on the top that's red is beds in the community. And this chart starts at 2001 and ends at 2016. And you can see that the blue line, these forensic beds, started overtaking about, I think 2013, started overtaking the civil beds. So this is part of the reason why we are seeing that we just don't have beds for community mental health treatment, because we've been overtaken by people being routed to the criminal justice system and the beds being eaten up on that side. So they just moved people from the state hospital to the criminal justice system. Next. So I want to shift to mental health and custody and talk about that just a little bit. Many times when you call the police for assistance on a crisis situation where you're wanting help getting your loved one to the hospital, it ends up in arrest. And probably about once a week, I have a family member in my office that is very upset and distraught because they called the police to help them. And the next thing they knew, their loved one is in jail with a felony assault of a peace officer. There's a couple of things, I guess, with that make it an issue. One is we do have many officers who aren't trained. The officers are supposed to be trained now under the law, but it just hasn't made its way all the way around. But also, we unfortunately have some officers that really weren't cut out to be mental health officers. They just don't have the personality for it. It does take a special officer to have the understanding to work with someone who's in a mental health crisis. We are very fortunate that many officers and all officers are supposed to be trained, and hopefully that gives them a leg up in responding to these crises in a good way with good outcomes. But we do see that persons having a crisis are often agitated and kind of hit that fight or flight mode, where then something goes south and they end up in the jail instead of a psychiatric hospital. And in an ideal world, that wouldn't be happening. And we still work all the time on training officers and trying to get an understanding of why this is happening and what has escalated it and how to truly address it. Next. So when an officer gets called out, they do have wide discretion, but it is limited by the department policy and the law on APOWs that we just talked about, because their policy is going to dictate whether they have to, when they have to arrest and when they should transport to a mental health facility. So that's another area for advocacy, is working on what department policies are. Many times department policies require handcuffing, or officers misinterpret the department policy to require handcuffing. And this is one of the biggest reasons that the situations escalate to an assault instead of just a hospitalization. Our jails have a very limited ability to address mental health issues. I put this picture of the restraint bed on here because unfortunately the county jail they're not a psychiatric institution. And when somebody is psychotic and banging their head on the wall or harming themselves, the restraint bed is often the only option that the jail has to protect the person. And that's a bit of a sad state of affairs for someone who's suffering a mental health crisis, to have to be restrained. It's unfortunate, but when there's criminal charges, there's also a limited ability to address it. And the criminal charges inhibit mental health services. So when someone comes in on a criminal charge, if it's a felony, we can't just say, oh, that's okay, they can go to the mental health hospital. We are required then to go to the court and request a bond and go through the process. And it's very time consuming and cumbersome. They also have their disability checks suspended, their Medicaid suspended. So then when a person's released, they no longer have those funds to go back into the community and directly back into housing. There's a gap to get that done. There's also gaps and lags in getting them registered for services in the community. So anytime that incarceration can be avoided, we're in a lot better place to get that person services in the community. Next. So a little bit on advocacy. So advocacy in the community involves holding agencies accountable for the CIT training, for officers using the CIT training in the field. So asking for records, asking for policies and procedures, knowing what those departments' policies are in handling crisis calls, knowing what their policies are about restraints and cuffing people when they're transporting on a civil call like this. We need to know what they're doing about jail diversion and diverting people under the statute I mentioned to you. How are they tracking it? Who are they diverting? Where are they diverting them to? What resources are they using? We need to ask questions, and we need to know the answers so that we can advocate for even more laws to address these issues. When we're talking about a person in crisis, advocating for their care and treatment. One thing, and this question also comes up as well, people will call and say, I need to get my loved one to the hospital. Let me get a guardianship or a power of attorney so I can do that. A power of attorney and guardianship might be able to help you with the person's financial needs and other miscellaneous medical things like talking to the doctor and medical prescriptions, things like that. But it will not allow you to commit someone involuntarily to a hospital. That is still always going to be done by the court. So it's not going to help you to get a guardianship or a power of attorney for that purpose. When someone's in crisis, advocating when you call the police department, asking for a CIT trained officer, letting them know that this is a mental health crisis straight up front. Reaching out, providing information to the hospital. As I said, the hospital can't call you and gather information, but if your loved one has been taken to the hospital, you can call the hospital and give them information. You just have to be very clear up front when you're talking to them that you are not asking them to tell you anything. However, if this person is in your facility, I need you to know this. And you can absolutely tell them things. Keeping those records so that you can provide them with an order when you ask for it from the judge is incredibly helpful. And advocating in the hospital. So there are, between in crisis and in the hospital, there's one common problem I see happening, and hospitals are required. Jen, can you flip to that next slide for a second? And I may need you to flip back. I just want to make sure if flip back. Thank you. So I'm going to go into that hospital one next. Let me go ahead to the jail. In the jail, advocating looks like a little bit the same as the hospital and the police, in that it's very helpful if you notify the jail of any diagnosis that the person has, any medications. You can also take the medications to the jail. Now, they're not going to give those medications that you brought, but it's incredibly helpful because they can look at the pill bottles, they can find out the doctor, the pharmacy, the dosage, the medication. They'll lock it up and release it to the person when they discharge. Incredibly helpful on getting a little bit of history to go ahead and restart meds or keep them on meds and that kind of thing. The more information, the better. Usually you can get it to the jail through the attorney, or you can call the infirmary. And again, they're not going to share information with you, but they can take information. Okay, go ahead to the next one. So as far as the hospital and being in crisis, I want to first tell you about the Emergency Medical Treatment and Labor Act. That was a law put into place in 1986 to prevent the dumping of patients who didn't have insurance. And the law says that the hospital must stabilize somebody who's in a mental health crisis. Go ahead and switch one more. So when an officer takes a person to a hospital who's in a mental health crisis, the hospital's required to stabilize them before they can transfer them to a psychiatric unit or release them. One of the problems that I see is that people are released without being stabilized in cases where the hospital sometimes finds out there's a criminal charge. They essentially say, oh, wow, if there's a criminal charge, yeah, go ahead, they're fine for the jail. They haven't been psychiatrically stabilized always. And I've also seen quite a few people who are indigent, in on criminal trespasses, that refuse to leave the hospital grounds. Maybe they've still, in some cases, they're still sick and didn't feel they got treatment for whatever it was that was ailing them. And the hospital has them arrested for criminal trespass. Or the individual was brought to this hospital from another city and they don't have a way back. And the law requires that they be taken back when released to where they were found. And it just seems easier for some hospitals to have them arrested and taken to jail than to have those people on their property. They just don't want people hanging around, loitering around. And we do see that. And that's a great place for advocacy, because that's where we should be making complaints. The reality is that when a person is in crisis and having a mental health emergency, they don't make complaints. They don't file complaints. And you don't see change if everybody just accepts it status quo. So we have to reach out, because EMTAL is a federal law, and violations of this federal law, the consequences are fines to the hospital for violating it. But it has to get reported for the agency to know it was violated. So that's another area for families to recognize that they can advocate, because it doesn't have a specific person that has to file this. Anybody can file it. You just have to have the information as to what occurred and be able to answer the questions they have as far as, where the person was treated and things like that. So that's another area of advocacy. We have to demand that people with mental health issues get the medical treatment that they need and deserve. Next. Another piece of EMTALA says that it doesn't matter what our state or local rules are, they still have to follow the federal rules. And so in our case, our state rules are that the officer is supposed to take the person to the nearest inpatient psychiatric facility. I'm sure many of you already know that somebody in a mental health crisis is generally taken to the emergency room, not an inpatient psych facility. That is because most of our psych facilities have made that a requirement, not because it's required by law. And this simply says that it doesn't really matter what our rules are or what our state law is, that the federal law trumps it. And the federal law says if someone in a psychiatric emergency shows up at the emergency room by whatever means, they must be stabilized. They must be provided stabilizing treatment. Next. So a little bit on the jail diversion. As I said, being put in jail does complicate things a great deal in terms of helping someone. But if we had our ideal world, what it would look like is that we would have a central place for mental health assessments. And when an officer encountered someone in a mental health crisis, they could take them to the central assessment place where they would be evaluated, and they wouldn't be arrested. They would receive treatment and be transported to whatever hospital had a bed or whatever was needed to get them the services they deserved and needed, including linking them with referral services, linking them with a local provider, getting them medication, and taking care of all these connections that they've missed, getting them required community support, and specifically housing and support services. Because one of the barriers is that if someone is in need of food and shelter, they're not really worried about their mental health needs. Those are the lower on the priority than food and shelter. And so we have to be able to help with all these areas, or we're not going to be successful. Next. Go ahead and go back to the slide. And in addition, on the jail diversion, we have mental health bonds, and the statute requires that anybody with a mental illness who could deteriorate if remaining in custody and who could get services in the community and who was in jail on a non-assault and non-violent offense shall be released on a mental health bond. These bonds require them to get mental health treatment, to follow up with their provider, to take their medication as prescribed, to show up for court. And our goal is to link them with the services and get them what they need so we don't see them back. So for example, years ago, it was the habit of jails all across Texas that at midnight, the person's time rolled. So at midnight, they were released, time served, or whatever it was. And, in Collin County specifically, our jail's off the highway and it's a good mile from a phone. So you have people maybe who are arrested in Plano or even parts of Dallas are arrested and brought to our jail, and they have no way back to where they came from. And so they're wandering around McKinney and they get picked up on a criminal trespass. Well, we just do it all again. And so you have that issue. You have the issue of many of them have lost their driver's license and their birth certificate. They have to have an ID in order to get mental health services. They would get on their medication in jail and be released with no medication. And then they couldn't get a psychiatric appointment for 6 weeks. So they were back in a deteriorated state again very quickly. So now in Collin County, we ensure that people who have begun taking their meds again in jail are released with 30 days of medication. We contact the local mental health provider, try to get them hooked up with appointments so that there is not a long delay in continuing that medication. We also do not release them at night. We release them during what we call coordinated release, where we hand them off to a family member or some other person who is coming to pick them up, or a mental health provider. We also, sometimes we use Uber for rides. We also want to get them a jail ID, so they have an ID for services. We try to enroll them in services before they leave so that they've got that hurdle taken care of. Our goal being to take as many of those hurdles out of the way towards them getting mental health services, and then we're more likely to be successful in the services. So that's where the focus is on it in jail. And in fact, our jail commission has even taken steps to require the release during daylight hours for persons with mental illness. We also make sure individuals who have IDD that are in jail, we try to release them directly to family. And our jail staff has been really great about identification of individuals very early in the process. There is a document that all the jails have to use. They ask questions of an individual when they're booked in about their mental health history and their current feelings and their medications, so that we can better serve them and route them correctly instead of finding out 5 days later that they're off their medication or whatever it is. We want to really get into those questions and get some answers so that we start from the moment they walk into the door, knowing there's a mental health need and working to address it. Okay, you can go to the next one. So I included my contact information up here for you. You know, we do what we can, again, for individuals in our jail. And I think we have a really good medical staff, fortunately, here in Collin County, and psychiatrists. So it's really terrific. And I will say we were doing really good before COVID in terms of addressing people's needs and coming up with longer term plans. COVID has really thrown a wrench in it, because we are seeing people come in very acutely ill, more so than before, and numbers higher than ever before. And so it feels a little more like a triage war zone right now, where it's whoever's the sickest has to be bumped to the first, and that's just all you can do because people are so sick. And so our jail staff continues to work on that, but the medical department's been great. And I've been seeing a lot of questions pop up, so I want to be sure that we're getting those answered. So I am going to flip back to Jennifer so that we can address some of your questions that have come up during this.
Awesome. Thank you so much, Alyse. I know me, myself, as a staff member, learned so much just throughout the presentation. And you are correct. We have had a couple questions come through. One, I'm going to start with pretty general. Somebody would like to know what resource they can access in Collin County for legal guardianship over their 28-year-old son.
Probably the resource I can think of in Collin County would be North Texas Legal Aid. And very often, if they don't have, for example, a lawyer on staff that does guardianship, they have a network of attorneys they reach out to seek some help.
Okay, awesome. And also, anybody, if you guys have any questions, things like that, we are opening up the meeting for question and answer portion. Feel free to drop that in the chat. Feel free to message me directly, and I will try and make sure we get to everybody's questions so long as time allows. We have another question. How easy is it to get a psychiatric advance directive, and what is the process, and is it worth the effort?
The psychiatric advance directive isn't, again, you cannot involuntarily commit someone. And that's usually the goal in getting any directive or power of attorney or guardianship is when my loved one is sick, I want to put them in the hospital. You will not be able to do that. So if that's the purpose, then no. And it kind of just depends on the purpose as to whether it would be worth it or not. I don't know in depth what the process is. I just don't see them happen very often.
And then the other one we have so far is, do other North Texas counties have similar jail release programs as Collin County? If not, do you know if other counties have any resources for people they release with housing or mental health issues?
Every county is different. Some counties are more robust than others. I know Dallas County has a similar program, and there are counties that have discharge planners at the jail that do their best to work on those. We have a grant from HHSC, which enables us to have a discharge planner at the jail. So that's just going to be case by case, and it's going to be different. The menu of services offered will be different based on the county and the funding and who provides it.
Righty, sorry, I couldn't find my mute button for a second. It disappears on me. Somebody would like to know if they would need to see a lawyer to create a power of attorney, or can their loved one put their wishes in writing and have it notarized?
You do need to use a state approved form, so all the elements are in there. However, there are a lot of people that use legal templates online for forms and have success with that. And again, it just depends on what you're going to do with it. I ran into this last week where I was trying to do a power of attorney related to a real estate purchase, and they wouldn't accept something. They're very technical about how to be drawn up. Is it a banking or is it a medical? I mean, there's just some specific things that you've got to be sure are covered.
Okay. And like I said, guys, we still have more than enough time. We've got it. Here we go. Here's another one. What steps can NAMI take to help educate law enforcement?
So I think NAMI has more power than they use. NAMI is made up of so many members with so many voices, but we have to have a united mission in getting together and asking our questions and advocating. We all have to have a purpose. And so in educating officers, part of that is asking departments. I mean, we can do open record requests. We can say, how many of your officers have been trained into this? What year are they trained? How many officers haven't been trained? Where are your mental health classes offered? Because right now I also find that agencies are in such a rush to get these classes done that they're doing a check the box training instead of quality training. And also CIT was designed as a team. So the whole idea was as a crisis intervention team, that you've involved your mental health providers, that there's this whole resource network. So I'm seeing a little bit of a mentality that because all officers have to be CIT trained, oh, we don't need a unit anymore. Everybody's trained. Why do we need that? And so we're losing the team piece. And it's critical. If you look at, we have 254 counties in the state of Texas, and I bet you there's not 15 that have a unit out of all of those counties. And so we don't have that team working relationship. I mean, we're fortunate in Collin County. I think we have a great working relationship with a number of our police agencies in this county. And it benefits our consumers a great deal in going forward. But I think we also have to hold the police agencies accountable, not only in asking those questions, but asking, what they're doing in this good faith effort to move forward. Because as I said, a lot of agencies don't even realize this is a law because it hasn't been used. And they didn't quite know what to do with it. We can also work in our legislation in terms of making it clear what our expectations are of police officers. And, overall, our police agencies do a good job. But as I said, not every officer really needs to be a CIT officer. And they don't have the mentality for it any more than every officer needs to be a SWAT officer, a canine officer, or a NARC. There's a different personality type for different jobs. And the officers who are truly CIT officers or in CIT units the great talent that they have is they're not in a rush. And the CIT protocol is take your time. You spend more time getting 10 crisis calls than spending the time and making it the one crisis call that's handled correctly and doesn't go south. So I love it when I see that officer took 2 hours on a call. I know their departments probably dislike it. They need them back other places. But the fact that they spent the time talking to the individual and it worked out in a positive light, and that person's less likely to be calling 911 tomorrow because this worked out. And so we have to continue to also offer training. I mean, it's great when NAMI and other agencies can help pay for training, for quality training for officers. And, departments' budgets are stretched just like everywhere else. And we have that opportunity to give them the training we want them to have.
Thank you. I really like that. Someone wants to know, what is the best way to prepare for a parole hearing for a person with high functioning autism? Are there any pro bono services accessible if they are indigent?
So I don't know about any pro bono services at the moment, but Bill Hayburn is a parole attorney in Texas and would be a good resource. I think when it's somebody high functioning in IDD, the important things are probably, they want to know about the discharge plan. They want to know about community safety. So having a plan for that. There is a proposed bill out right now regarding developing a legal counsel office for TDC. And so that might be an important thing to follow as it moves along.
Thank you. We do have about 10 minutes left. If you guys have any more questions, things like that, feel free to put them in the chat, and I will make sure Alyse gets to hear them if you have any questions.
Everybody's quiet tonight. So one other thing that's important is that generally speaking, when someone has mental health issues and we go to trial, their mental health really doesn't play a role until punishment, and it's for mitigation. We don't really get to talk about their family life and their growing up and their struggle with mental illness until that point. So it's very important also for family members to be involved there in sharing information with the attorney and providing a history that they can use. And I know sometimes it's hard because family members get burned out. You try to help somebody so long, but it's just crisis after crisis. And at some point then I've seen family members who are scared when their family members home because there's been assaults, or there's been holes in the wall, or there's been other kinds of things that are disruptive to everyone else living in the household. And it's very hard. And we've also had a number of family members who are excited because of the mental health bond. That loved one is now on medication and doing so much better, and they've been able to rebuild some relationships. And so that's been really great to see.
Someone would like to know, for someone who is incarcerated, do they have any access to mental health services?
Yes, but it's limited. And that's where part of the frustration comes in, is that our jail is not a psychiatric institute. We do have 2 psychiatrists, and other jails have psychiatrists or medication. But again, there are so many people so acutely ill that it is literally a triage. You're supposed to have a follow-up with John today, but James came in and he is so acutely ill, the doctor's got to see that one. And it's not counseling, and it's not education on medication and all the things you would get in an inpatient facility. It is a Band-Aid, and it's trying to get them back on their meds, but it is not mental health treatment as it should be.
Building on that, somebody asked, are jails required to give appropriate medications while in jail. I know oftentimes, to continue to build on that, I have loved ones call me whose family members are incarcerated and say, I need to get them their medication. They're in jail. I don't know if they're going to have any mental health services. Is there even anybody I can speak to? So just building on are they giving appropriate medications while in jail or required?
So if they're on mental health medication, the jail tries to verify the medication and make sure they continue on it. Very frequently, a family member will call and say, John's taking this and the jail's not giving it to him. Well, when you look at the bottles, John hadn't taken it in 30 days. So that's not a current medication. So a doctor would have to see him and reevaluate in order to start it. Also, a number of medications require blood work and labs. So it's not just, oh, he was on this, we just automatically put him on it. It requires some information. If people come in and they want their meds restarted, that is going to take time to get an appointment, but they'll will do that. And necessary medical meds, same way, if a person's diabetic or something like that, they're going to get those meds. It's not always the same meds, sometimes it is generic instead of formulary and that kind of thing. For example, one med that we're starting to see more of is Invega. They don't give Invega in jail because, as you know, that's like $3,000 a pop. Generally, they are on some pill form while in custody until they can transfer that.
Somebody would like to know if you have any recommendations about how to educate a well-intentioned attorney about the implications, etc., of illnesses like PTSD, anxiety, or other mental health conditions.
A lot of times I will see individuals email an attorney my name and number and say, hey, I stumbled on this for information. Would you mind reaching out to her? Or they'll reach out to me and say, would you mind reaching out to this attorney? Because we still have a large number of attorneys who aren't educated as to mental illness. And, I'm surprised at the number of people who say, oh, I know you said that person has mental illness, but they're not having any problem in jail. They're not upset and they're not this or that. And I have to explain to them, yes, they've been functioning well, but now we've put them in a jail in a strenuous environment and they can quickly deteriorate because of the circumstances they're in. So it's a preventative thing as well. But some attorneys just haven't had a lot of cases. They haven't had to recognize it. So they aren't educated on it. It's a new area. And, one important thing about that is it changes the scope of your representation. So for example, if somebody without mental illness was arrested for a criminal trespass, they might choose to take probation because they don't want to spend time in jail. So they might be willing to accept a year probation. Whereas a person who suffers from mental illness that's homeless, a year of probation would be impossible for them to navigate. And so a 5-day time served at jail might be more appropriate. And so as an attorney, I have to learn that what I think might be most appropriate isn't necessarily what's best for my client, who has a different set of life circumstances.
Give me 1 second. I've got one more question that I think straggling down. Give me one moment. Let me get in touch with that person. All righty, we are pretty much down to the hour. If you guys have any more questions, here's one last question. Who makes the courts aware of the mental or the mental history of an inmate?
So under the Sandra Bland Act, the jails are required to do a mental health assessment on anyone who comes in the door that the judge orders that has a mental health history. Now, that assessment isn't anything in depth. It's merely a recitation of their mental health history. And so that report goes back to the judge and by law must be given to the defense attorney, the state, and the trial court. So that becomes part of their record. But in terms of the actual case disposition, that is on the defense attorney to educate the court, even though that document's there.
I'm going to squeeze in one more question, if you don't mind. A couple last minute ones coming in. Someone has a loved one in the Collin County Jail for a felony and history of mental illness. How is he handled?
I'm sorry, I missed the last part.
Oh, it was our loved one is in Collin County Jail for a felony. Oh, sorry. And a history of mental illness. How is he handled?
So once we've identified that, they're going to be routed to the psychiatrist to determine if they have medication needs. Keeping in mind, just because they're routed and just because the family calls and says, I want them on the medicine, doesn't mean that client's going to take it. They can still refuse. And so they'll be routed through to see the psychiatrist. If they're willing to accept medication, the psychiatrist will determine what they need to be on. They'll be monitored routinely with regular follow-up appointments and whatever other services are needed for that medication, whether it's lab work and levels and that kind of thing. They'll also see the mental health counselors. We do have an infirmary and we do have kind of a satellite infirmary. So if they're not able to function in the general population, sometimes their anxiety is just too much, or they're having problems with other people, or they need more privacy. Those kind of things, they'll move them to these other units where they can function a little better and they have more medical attention.
Sorry, I'm trying to get this one question that let's see, I think it came in. I just want to make sure I at least try and get the question, or if anybody hears it, maybe someone wants to know if you can address if violence was involved in the offense. It was a little further back, so.
If violence was involved in the what?
In the offense.
And what's the question about it?
Oh, I was wondering if that maybe jogged your memory of maybe a specific offense you were talking about. I do want to make sure that I at least tried to ask it. I reached out to the individual. So if you did have a question about violence earlier, feel free to reach out to us at NamiNorthTexas.org or info@NamiNorthTexas.org, and I will make sure that Alyse gets that question and we can get you an answer to that. Similar, and that goes to anybody on this webinar currently. We are down to the wire. We're just about at the hour. So if you do have any more questions or any questions that you think of after this webinar, feel free to reach us. And what I can do is I can put our email in the chat and then we can make sure to connect it. And what we can probably do is, at least if we do get a series of questions, I'll probably send it all to you in kind of like a Word doc and we can get that put up on the website. I know we're making a couple changes and this webinar will be able to be viewed about Monday, Tuesday, early next week. Couple reminders before I let you all go. Please don't forget we have our general membership meeting on April 15th at 7:30 p.m. That one's going to be titled NAMI Walks as a Community. Deanna, our development director, is going to be talking about NAMI Walks Your Way, the impact on the community, and why it's so important for us to be able to fundraise and continue to provide our services at no cost. The unique thing about that one also is we're also going to be featuring some of our community sponsors. So it's kind of going to be like a virtual resource fair. And they're going to be able to talk about what services they offer the community. So registration is open for that now on the NAMI North Texas website. Other than that, I would like to thank you guys for joining us this evening. And Alyse, thank you for taking the time out of your Thursday evening to be able to provide us with this wonderful educational webinar. We truly appreciate it.
Thank you.
Hope you guys have a great evening and we hope to see you for a general meeting on April 15th.